Thank you for clicking this video. This is Battle with Ola and my name is Mujola Oluwa. As you probably already know, we're now on Instagram as BTW Everyday, at BTW Everydays. That's a place on Instagram where we want to curate our own content and keep the law conversations going. Please give us a follow on Instagram and share with your friends and family. So our first follower is Jennifer, and Jennifer asked a question by DM, which I promised to look into. Now, we don't want to take DMs on Instagram. We want it to be limited to emails at houseoflivingstones@gmail.com and comments on the YouTube channel. But because she was our first follower on Instagram, we are giving her this video. She has asked us to talk about the rudiments of mock trials. So that's what we want to talk about in this video. Don't forget to give us a follow on Instagram. A mock trial is a trial that's not real, but possesses all the elements of a real trial. So there's a lawyer, there's a judge, there's a court, there are parties on either side, represented by lawyers on either side, and there's an actual cause of action that is being litigated upon. The only thing is that the judge is not a real judge, the lawyers are not real lawyers, and the parties are not real parties, and the cause of action does not really exist in real life, but it's a simulation of a real trial, which is often conducted by students, as part of their training, at the university level or at law school. There were mock trials, at my university level and at law school, although I was not a part of any of them, but I remember that I represented my chambers, H.O. Davis Chambers, as a co-counsel in a case that we filed on behalf of the Attorney General of the Students, Law Students Association, Law Student Society at the time. We had sued a lady who was part of the audit committee auditing the executive and had then been appointed by the executive as well into a political post. So we were contending the legality of the appointment because she is auditing you. Why are you hiring her again for another role? Do you not mess with the integrity of her work as an auditor? Essentially, that was what the trial was about. I was co-counsel to a young man called Victor Jetayo at the time, and we had a great run, with the trial. So I'd say that's the mock trial that I was a part of. And of course, at law school, I was part of, I think I did research for my mock trial team at law school. So mock trial is really more about teamwork because you're not alone. This is not your law chambers where maybe you are the one representing the client alone, or whereby the principal or your superiors handed the file to you alone. It's teamwork. There are other people in the group with you. Usually they will assign you into groups for mock trials, and then each person has a role or has like a general notion of what they're supposed to be doing. So if you've watched the videos that we've done on trial on this channel, I'd say you're good to go. So Jennifer and everyone that wants to know more about mock trials, I highly recommend the videos that I've done on evidence giving, on plea, taking of plea arraignments, on written address, writing your written address, filing your written address, adopting your written address, on tendering documents, and the whole works. So please, I'll leave a link to those videos in the description box. And I might also much later try to put them in a playlist, maybe a trial playlist. So if you watch those videos, you are good to go. Trial opens. Let's use a criminal trial now, because in most mock trials, a criminal trial is used because it's better for understanding. Civil trials are more generic, so criminal trials are better for mock trials. There are civil mock trials too, but I'm going to use a criminal trial as an example here. So a criminal trial opens by arraignment. Arraignment is the process by which you bring the accused person to court to answer the case against them for the first time. So we don't mention criminal trials. In civil trials, you first come to court for mention before you come back for PTC and then for hearing. That's the trial proper. But in criminal trials, once the charge has been filed, the accused person usually is in detention. So once the charge has been filed, when it's trial date, it starts by arraignment. The accused person is put in the dock unfettered. So very important, take note of it. They must be unfettered, put them in the dock, and then the charge is read to them in the presence of the judge by the registrar, and then they have to take a plea. say they are guilty or not guilty. If they cannot speak the language, they must be provided an interpreter. It's a constitutional provision. And they must have a lawyer. It's also a constitutional provision that they must be afforded the time, to prepare their own defense, which is to get their own lawyer. So they must have their own lawyer. The charge is read to them. They plead guilty or not guilty. We talked about pleas extensively in the video that I did on arraignments. So after taking their plea, trial commences. And trial commences by the prosecution calling their witness, prosecution witness 1, who is placed in the witness box, who takes, swears on the Holy Bible or Quran. After swearing that whatever the evidence they want to give is going to be the truth, the whole truth, and nothing but the truth, the prosecution starts to lead them in evidence. That's examination in chief. That's examination in chief. We've done a video on examination in chief, cross-examination, re-examination, a few videos actually, so please watch that as well. I've even done practical videos on examinations, using some scenarios as examples. Please watch them all. I will try to link them in the description box. Please look for them on the channel and watch them. So after the prosecution leads their witness in evidence, they turn the witness over to the defense for cross-examination, then back to them for re-examination, and then the defense will do the same, and then the trial will close by fixing a date for parties to come back to file their written addresses. Usually 21 days, both parties have it. It's counted together, 42 days. Then they come back and they adopt the written address that they have filed and exchanged with each other. Now, a written address is the final argument in the matter. Instead of saying it orally, like in some places, in some jurisdictions, in Nigeria, you say it in writing. So after that, parties will come back to court, adopt their written address, and then the court will adjourn for judgment. So on the day of judgment, parties will come back to court, the defendants will be brought, and then the judgment will be read. And the judgment will be executed, or a party would apply for stay of the judgment because they want to appeal. So you can appeal the judgment of the court, and there are time limitations to appealing as well. So that's basically what a trial is about. So you may need to also mind court orderliness, who the judge is, who the counsel will be, what they would wear, how they would look, all those things. You sort them out at group level. So I think the most important tips that you need to bear in mind about mock trials are: 1, you must familiarize yourself with the scenario, because it's a mock trial, just like in real trials, where you must familiarize yourself with the facts of the case. You must understand the scenario. What exactly? Are you prosecution? Are you defense? If you're prosecution, make sure you're not doing the work of the defense. And if you're defense, make sure you're not making the case of the prosecution easy. So, we're using a criminal trial here. What has the accused person done? What's the cause of action? What's the case before the court that the court wants to adjudicate upon? And what's your brief? What's your role? What have you been asked to do? If you are made a court registrar, for instance, you know that what you need to do is, attend to the judge, do the judge's bidding, and keep orderliness in the court. So you're probably the one shouting order court when people are making noise. You're probably the one that will read the plea in a criminal trial, that will pass the file to the judge. You sit in front, you dress corporately, formally, So if you're a judge too, what do? You sit upon the case. You sometimes ask questions, because a judge can also ask questions when parties are conducting their case. You make sure you caution a party or witness or anyone in the court that's going out of the scope of their functions, and then you also decide the case. So you hear the parties. And if you're a lawyer, you have to do extensive research, what you say, how you defend your clients, the questions you would ask. You need to prepare your examination questions or your cross-examination questions. Practice it with your client or with the witness, in the matter. So just familiarize yourself with the facts of the case. Make sure you understand why you're going to court. Just pretend that it's a real matter and that the life of your client might depend on you. Yes, so that's 1, familiarize yourself with the scenario and understand it properly. 2 is you must understand that this is teamwork, so you're not alone, okay? Although roles are usually assigned, there are some people that just do general work, so what they do is research, they just help here and there. So if that's your role, make sure you're supporting the group and supporting people who have particular roles. And if you have been given a particular role, use these people, use their resources, let them do research for you. If you don't understand something, maybe you're going to court on the charge of murder. What is murder? Try to understand the ingredients of the offense. If you're prosecution, you know your job is to prove the ingredients, not necessarily to nail the accused by fire by force, but prove the ingredients that this and this and this and this has happened, and we can sufficiently link the accused person to the commission of the crime. So, and if your defense, disprove the case of the prosecution. So you need to understand that it's teamwork, and you must focus on the greater good of the team, which is to win, to score your marks. So anything that might remove from that, even if you're personally convinced otherwise, make sure you do not do it. So it's teamwork. And the third thing that you need to avert your mind to is that this is preparing you for real life trial. So let your mind be in it. So do your best. And don't take it with levity. Third thing and most important thing to note is that this is a mock trial. You're being assessed. In real life, nobody's really assessing you, you know. You're probably going to be assessed in the court of public opinion and your client's opinion, but here you're going to be assessed, you know, for school. So make sure you follow the guidelines. If they have said this is how we want it, even if you know or have some experience about real life practice and that's not how it goes, make sure you stick to what the school or the tutor or instructor is asking you to do. If you know that, oh, this particular lecturer, they look out for something like this, make sure you incorporate it into your own trial. So very important, eye on the goal to score your marks. So put your mind to that. So that's all I want to discuss with you in this video. I will see you in my very next video. Don't forget to subscribe to this.